Today we are going to be talking in terms of section 144 of the Code of Criminal Procedure, the CRPC, popularly called दफ़ा 144, वो नाफिज हो जाता है, and the popular belief is that it prohibits the assembly of 5 or more persons in public places. And in the small talk, we are going to be talking in terms of what exactly is this section 144 Code of Criminal Procedure, who can promulgate it, under what circumstances, what happens when it is promulgated, for how long can it remain promulgated, and in case there is any disobedience or defiance of the order under section 144, is there any criminal offense? How can you be proceeded against? Can you be punished? So, this is a very potent tool as a preventive measure in the hands of the district magistracy, which is headed no doubt by the district magistrate, to take care of potentially dangerous situations which can cause loss of lives and obstruction, injury, annoyance, danger and apprehension to health and so on. So, first of all, we should clarify that section 144 has nothing actually to do with assembly of 5 or more persons. Of course, when you want to ban it, you can invoke this section. Even curfew is invoked in this particular section. When you ban carrying weapons, even licensed weapons in public, this is invoked. So, therefore, per se, section 144 has no one-to-one correspondence with assembly of 5 or more persons. Perhaps historically it has been used because an unlawful assembly must comprise 5 or more persons. But if you go through the section 144 of the Code of Criminal Procedure, you will not find any mention of an assembly of 5 or more persons. Now, who can actually invoke section 144? It can be invoked by the district magistrate, who is the deputy commissioner or the district collector. It can equally be invoked by the subdivisional magistrate, the SDM. A normal executive magistrate cannot invoke unless he or she has been specifically empowered in this behalf by the state government. So, therefore, the only 2 authorities to whom the law gives the power to impose section 144 are the district magistrate and the subdivisional magistrate. I am not talking in terms of the police commissionerate system, where some powers of the district magistrate are conferred onto the commissioner of police or the additional commissioners, but effectively the power to invoke section 144 is vested with the district magistrate or the subdivisional magistrate. Even the state government cannot directly, the Home Secretary, the divisional commissioner, they cannot invoke. They have a role in modifying, revoking, resigning, that is a separate matter. So, first thing we need to understand is that it is only and only the district magistrate and the subdivisional magistrate who can invoke section 144. Now, when can you invoke? When this magistrate has information, reasons to believe, what is called the subjective satisfaction. He can be reading newspapers, he can be getting CID reports, he may be having his formal and informal channels of information, and he believes that this is an urgent case for some preventive measures to be taken under section 144. So, what are the conditions precedent? The subjective satisfaction of the magistrate, to what effect? That this could cause, unless the order is issued, it could cause obstruction, injury or annoyance to people lawfully employed. For instance, you are building a national highway and a bridge and some people are agitating for whatever reasons, and you feel that you need to impose to protect people lawfully employed, to prevent obstruction, injury or annoyance. So, that is one level. The other is when there is danger to human life, health and safety. Now, that's very important, especially in the context of epidemics, in case of riots, in case of communal riots, in case of unlawful assemblies. So, what are the other conditions? Danger to human life, health and safety. Not only that, disturbance of public tranquility, riot or affray. If this could happen, so in that case, the magistrate can invoke section 144. He may impose a curfew and say that no person will step out. He can say assembly of 5 or more persons is prohibited. He can say even assembly of 2 persons is prohibited. Assembly of not more than 50 is allowed. So therefore, it is very clear that the condition precedent is that he is trying to prevent obstruction, injury or annoyance or danger to human life, safety, health and of course, more dangerous cases like disturbance of public tranquility, riots and affray. So he then passes a restraint order. So this is very important. The magistrate restrains you from taking some action. For instance, he says, please don't step out of the house or after 8 p.m. Within that order, he can mention that, or for the next 24 hours. So therefore, it is a restraint order. He bars you and bans you from carrying weapons in public. He may even bar you from carrying a lathi in public. He may even ban you and bar you from carrying swords and knives in public on the grounds that it would prevent any disturbance to public tranquility, riot, affray and so on. The magistrate can also direct you to take action qua certain property under your control. For instance, Arms Act, not to carry arms. You may ban the running of vehicles. So you are restraining the owner, the manager from taking some action qua that property. But it is a restraint order. The magistrate cannot direct you to do something. Even if you couch it in positive or negative language, the magistrate cannot say, I'm passing this order, so you will collect in this ground and there is a public rally and you must join. No. He has to only restrain. It's a restraint order and it is in writing promulgated through press, through the beat of drum, internet, website, whatever method. People at large need to come to know that a particular order has been passed and what is the content of that order. And generally this order is passed ex parte. I mean, if there is a Muharram Jaloos coming, a procession coming, which has been banned and it is passing through the majority community and he apprehends there is going to be riots, where is the question of serving notice and calling for objections? So he will promulgate that order overnight and it will be then the business of the police to implement that order. So it is passed ex parte. Now the law gives the magistrate up to 2 months to pass this order. The order passed today can last at a maximum for 2 months. And thereafter, the state government can, by notification in the Gazette, extend it. The state government can extend it for up to 6 additional months. But state government can also alter, review and revoke. But mind you, as I said, the original imposition and promulgation is within the domain and the prerogative of the magistrate, who is supposed to be the person on the spot, the eyes and ears of the government, having his formal and informal sources of information and saving the life and limb of the population and preventing riots, health hazards, danger to human life, and of course, obstruction, injury or annoyance. Those are the powers given to the magistrate. So therefore, magistrate passes the order. The order is generally in the nature of a restraint order, can remain in force for a maximum of 2 months. Generally, it is passed ex parte, and thereafter it is enforced by the police. Now, what happens if some person defies, if there is a disobedience of that order? Section 144 gives the powers to the magistrate. But what happens if you say, okay, I am going to go against this order? You have said no more than 5 persons to assemble. Here we are going to have a procession of 50 people and we are going to get onto the streets and defy. So then immediately Section 188 of the Indian Penal Code, I repeat, disobedience of an order promulgated by a public servant, that is the language used in 188 IPC. There is no direct mention of Section 144 CRPC in Dafa 188 of IPC, but the language used is virtually the same. So therefore, a person who knowingly, the knowledge is very important. If you are coming and the order has not been promulgated and technically you bring your car into a curfew-ridden area, you could be having a legal defense that I didn't know, sir, that this order was enforced. So knowingly, and there is disobedience of that order, then it is a cognizable offense. The police can arrest you there and then without a warrant from a magistrate. And what is the punishment? The punishment is classified into 2 categories. If the disobedience is merely causing obstruction, injury and annoyance to people lawfully employed, then it is a maximum of 200 rupees of fine and 1 month of imprisonment. That is, you can, after trial before a magistrate, be sentenced to either fine or both, but the maximum imprisonment is 1 month. But if it is only confined to an area when your disobedience causes or tends to cause obstruction, injury or annoyance to people lawfully employed. But if the disobedience is in the nature where your disobedience causes or tends to cause danger to human life, health, safety, which will be very, very relevant in the COVID scenario, or in case of a communal tension, communal rights type of situation, where it is likely to cause disturbance of public tranquility, riots or a fray. You may not cause it, but it tends to cause. Then a higher punishment is envisaged in Section 188 IPC, and that is up to 6 months and rupees 1,000 fine or both. So therefore, just to rehash and revise, Section 144 are the restraint orders, whether curfew, unlawful assemblies or bigger assemblies not allowed, banning of pillion riding, any type of order with the objective of preventing danger to human life, preventing riots and so on. And should you do so, should you violate, then Section 188 IPC comes into place, and a regular trial, you can be arrested without a warrant, and then a regular trial before a magistrate, and you could be given imprisonment. I mean, you will have all the rights to defend yourself, your lawyer, prosecution evidence, cross-examination of witnesses, that thing will apply. But one more section which I would like to touch upon, in case of criminal cases which are registered under 188 IPC, one has to refer to Section 195 of the Code of Criminal Procedure. So therefore, what that particular section says is that, okay, it is a cognizable offense. The police can register an FIR, bring about their investigation. But once the matter goes to the court requires a formal complaint by the very same public servant who promulgated that order, the district magistrate who promulgated that order, the subdivisional magistrate, there has to be a formal complaint before the magistrate so that he is able to take cognizance. Because the situation may have been diffused, police investigation could have taken 1 year, political persons could have been booked, farmers in their thousands could have been booked and named and arrested and let out on bail. But now the matter has been diffused and the state government feels, the district magistrate feels that no useful purpose would be served by going with this trial. So he will then in that case not give that formal complaint and the case will stand dropped. So the officer who promulgated that order or to whom he is subordinate, they are the ones who can give that particular complaint to the magistrate. And also where a public servant who's promulgated the order has given a formal complaint, his superior authority can actually withdraw. So number of times you hear that while these cases were pending and whether under investigation or within the court, they have been withdrawn. So specific powers are given under section 195 of the Code of Criminal Procedure. The only and only ground is that the trial should not have concluded, because once the trial concludes, then there is only two things that can happen: either you are convicted or you are acquitted, and that would be too late in the day for the executive authorities then to step in. But definitely it is very clear that for a proper trial to begin, you need, apart from the police investigation, a formal complaint by the public servant who promulgated that order. डीसी साहब ने ऑर्डर अगर किया था तो डीसी साहब की फॉर्मल कंप्लेंट जुडिशियल मजिस्ट्रेट साहब के पास चाहिए फॉर हिम टू टेक cognizance. There are two other sections which I would like at this moment to bring to your notice. They are used extensively but are not very popularly known. The police has not only the duty to investigate cognizable offences, there are also duties imposed on the police to prevent offences. And as we say, prevention is better than cure. So sometimes you say from this point onwards, section 144 or curfew is in place. And there you are, persons, sometimes members of parliament, senior people, political personalities, other associations, they say we will want to cross. How is this sub-inspector, how is this head constable standing there? He's trying to stop us. Is there any provision in the law? Please let us know. Section 149 of the Code of Criminal Procedure. It is the duty of every police officer, and every police officer, right from the Director General of Police to the lowermost rung, which is the constable, he may interpose for the purpose of preventing, to the best of his ability, the commission of a cognizable offence. So therefore, if you are standing at the territorial edge of your jurisdiction, your thana, your subdivision or whatever, and there is moving an assembly which in that jurisdiction is not an unlawful assembly, but the moment they cross into your area, you've imposed curfew, you've imposed 144 by way of banning of assembly of 5 or more persons. So there the police will say, I am interposing, because the moment you are stepping into this territory, you are committing or would commit immediately a cognizable offence, which is an offence under 188 IPC. So he's actually giving you a chance. He could very well say, you cross over here and I will then arrest you without a warrant, this being a cognizable offence. So he will interpose to prevent the commission of a cognizable offence. Section 149 does not give the power to the police to prevent non-cognizable, which are, offences of minor nature. At the same time, we also have section 151. Now, this is again a beautiful preventive section. If a police officer feels that, in spite of his interposing, preventing those people, you still are adamant, you want to break the law, you're pushing, you say, okay, you do whatever you want, then section 151 of the Code of Criminal Procedure says that any police officer, again no level has been given, from a lowly constable to the Director General of the Police, he can, without warrant from a magistrate, arrest a person if he feels that there is no other way to prevent the commission of a cognizable offence. Now, it's a different thing that this section 151 is often used in the other preventive measures like 107 CRPC, but maybe that is another talk for another day. But definitely he can arrest you if he feels that you have not yet committed the cog offence, but if he is satisfied there is no other way, you are adamant, so then he can definitely arrest you to prevent you from committing that cognizable offence. And of course, within 24 hours you have to, present you to the magistrate. In the meantime, if an FIR under 188 IPC has been registered, then of course it would be an arrest under 151 leading to an arrest under 188 IPC, and then of course whether you get a bail or not, all those things will come into play. So therefore, to summarize and conclude, a magistrate promulgates an order under 144 CRPC. It restrains you, and the idea is preventive, to prevent loss of limb and lives, prevent riots. And should there be a disobedience knowingly of this particular order, and that is likely to cause obstruction, injury or annoyance, or health, safety, riots or fray, then a criminal case can immediately be registered under 188 IPC, and you can be arrested without a warrant. Within 24 hours, one goes before the judicial magistrate, who may let you off on bail or not. And then after the investigation begins, but before the charges can be framed, before the judicial court formally takes cognizance, a formal complaint by the public servant, the DM or the SDM is required. In absence of that, the case cannot proceed further, and this permission, even if granted, can be withdrawn by the higher authority. So therefore, these are the sections under which the local district magistrate and the local subdivisional magistrate have been given powers, because they are the persons who are very close to the spot. No person sitting in the state capital, not even the state home secretary with all the inputs from intelligence and so on, can have an appreciation of the situation. And the courts normally do not go into the subjective satisfaction that is the CID report, is this newspaper report enough for the magistrate to take the particular action that he took in imposing. Of course, there has to be some information, there always is, but the sufficiency of that and whether the magistrate was right in reaching, was he kind of being conservative and so on, the courts do not go in. So therefore, 144 is the section which is invoked by the magistracy. The disobedience thereof becomes a cog offence under 188 IPC. You can, depending upon the gravity of the offence, be face imprisonment up to 6 months or 1 month, and of course the same public servant who promulgated the order can withhold the complaint and the case can drop. So the idea is to prevent damage, The idea may cause you inconvenience, you may feel that your civil liberties are curtailed, but life and limb and properties and rights, the damage is much more, and a lot of responsibility is cast upon the young magistrates out there in the districts, and generally they invoke this to prevent lasting damage, which can then extend more than and beyond the lives, especially when the communal and the religious type of sentiments get involved. So this, friends, was a small little talk that we had on Dafa 144, section 144, read with section 188 IPC, under which it is punishable. And if you think that similar talks on other well used and well known sections of Code of Criminal Procedure would be useful, I'll come out with short videos. And if you feel that there's some friends and followers who would appreciate, be benefited by this type of video, please do like, comment and share, and also subscribe for a variety of short and brief videos that I would be coming from time to time. Thank you.